We'll start our sales course by considering the scope of Article 2 of the Uniform Commercial Code, or UCC. Article 2 applies to transactions in goods. Although the UCC doesn't actually define a transaction in goods, this term covers more than just contracts for the sale of goods. However, most transactions that fall under Article 2 are sales of goods. A sale is the transfer of title to goods from a buyer to a seller in exchange for a price. Article 2 covers both present and future sales of goods. For example, imagine that a student wanted to purchase a laptop from an electronics store for $800. If the electronics store gave the laptop to the student in exchange for $800, a present sale governed by Article 2 has occurred. Now let's say the electronics store only agreed to sell the laptop to the student after she completed a cybersecurity class. This was still a sale governed by Article 2, but it's called a future sale because the agreement contemplated that the transfer of ownership would occur sometime after the agreement was made. Article 2 defines goods as all things that are movable at the time of identification to the contract for sale. Things such as clothes, machinery, agricultural products, and even electricity are goods. On the other hand, an in-ground swimming pool isn't a good. A thing able to be severed from realty can also be a good, even if it's not movable when the contract is made. This exception generally covers minerals to be removed from real estate, structures to be removed from realty, and crops and other things attached to real property. Let's use two examples to illustrate this exception. First, imagine that a mining company agreed to sell a specified quantity of coal from its mine to an energy company. At the time, the coal hadn't yet been removed from the ground, and under the contract, the mining company was to extract the coal. Although the coal wasn't movable when the parties entered the contract was one for the sale of goods, because the seller was to extract the coal. If the contract required the buyer to extract the coal, then the contract would be considered one affecting land, not one for the sale of goods.